Hello, and welcome to IPWEA Victoria's Professional Engineers Registration Act 2019 update. The material in this presentation is taken mostly from engage.vic.gov.au/engineers-registration. That's the state government's consultation portal. And a lot of the information, a lot of the content is based on the public consultation materials released by Consumer Affairs Victoria on the 26th of August 2020. And just a note that if you want to make a submission against these consultation materials, submissions are due by the 7th of October 2020. Just by way of introduction, my name's David Hallett. I'm the CEO of the IPWEA Victoria, and whilst I'm not an engineer, I do have form as a 6-year representative on the Architects Registration Board of Victoria and 3-year term on the Building Practitioners Board. So I've got some background in the regulation of built environment professionals. This webinar is being recorded. It'll be made available from our website, ipwea.org/Victoria. I'd ask everyone to mute their microphone, please, to eliminate any background noise. Extracts from 6 of the 8 consultation documents that we've incorporated into this presentation look like this slide, so that will help you identify the fact from the fiction, if you like. If you've got any questions, please enter them via the chat box during the live session, and if you have any questions subsequent to the presentation, please by all means send those to vic@ipwea.org. Now, whilst you're listening to this presentation, I'd encourage you to think about it on 2 levels. One is as an individual, but also on behalf of your organisation, because we think it has implications for both, even though registration, of course, attaches to the individual. There are implications for staff roles and responsibilities, obviously the engineering staff, but including the managers of engineering staff potentially also the outdoor staff, including their supervisors. And there's implications for the registrability of the people in those roles that require registration. There's implications for employment agreements, position descriptions, remuneration, and reimbursement potentially for compliance costs associated with becoming and maintaining registration. And for some organisations, and I'm thinking particularly of smaller regional shires, there might be even bigger decisions to be made about insourcing versus outsourcing engineering services. Just to recap, some of you will have seen some of these slides before, but the biggest question that has been asked for the last few years is why has the government introduced a registration scheme for engineers in the first place? It's fairly straightforward. It recognises that whilst engineers do some of the most important work in the built environment, in our case, they are unregulated and perhaps least recognised of all of the other professionals involved in the team. So this legislation recognises that and is essentially a consumer protection initiative. In terms of reach, it's worth explaining that, and this is the first slide that is taken from those consultation materials I mentioned earlier. You should be able to tell that by the look and feel of it, or the absence thereof. There are 3 instances where the Act applies. It firstly applies to people located in Victoria providing services for Victoria. It applies to people in Victoria providing services for outside of Victoria. But also, and quite importantly, it applies to people outside Victoria providing services for Victoria. And I'm thinking there of engineers, particularly in consulting firms or contracting organisations based outside of Victoria, but providing services for the state in some way. So that slide there very simply explains the reach of the Professional Engineers Registration Act. Now, this slide's been around a little while. It explains the registration requirements. You'll need to be registered if you meet all of these conditions. You provide a professional engineering service. The service falls within one of 5 areas of engineering, and your work doesn't fall within one of 2 broad exemptions. That is the direct supervision exemption and the prescriptive standard exemption. We'll talk about each of these things in detail now. The first thing to explain is guidelines on what is and isn't a professional engineering service, and all of the information on these next several slides is taken from the consultation materials. The guidelines on providing professional engineering services identify 4 elements of such a service, and they are that the service is an engineering service, it requires the application of engineering principles and data, it relates to the design, construction, production, operation or maintenance of something related to engineering, and it's not provided only in accordance with a prescriptive standard. So if we look at these things each in turn in a little more detail, the first is that the service must be an engineering service, and this information identifies what a service is in the first place very broadly. It's to be an activity, supply of work or skill that's offered by or performed for another person. So an engineering service is such a service that is concerned with engineering and is typically performed by an engineer. It might be performed for or on behalf of a client, and it might be performed internally within an organisation, such as by an employee engineer for or on behalf of an employer. For the purposes of the Act, it includes any services that requires engineering education, training and experience, and may include, for our purposes, consultation, evaluation, engineering studies, designs of engineering works and systems, drawings, specifications, reviews and advice, and other technical submissions, and the reviewing of construction or other design products for the purposes of monitoring compliance with drawings and specifications related to engineering work. So a pretty broad definition, but one that needs to be taken into account when you're trying to determine whether what you do constitutes an engineering service. Further information relates to the service requiring or being based upon the application of engineering principles and data. Engineering principles are defined as the ideas, rules, or concepts used to solve an engineering problem. And engineering data is defined as the data used in the application of the principles. So, whereas the principles are based on applied science and mathematics, the data, for example, might be in the form of drawings, specifications, standards, application of standards and codes. Therefore, to be a professional engineering service, the service must require or be based on the application of scientific and mathematical principles and data to facilitate the design, construction, production, operation, or maintenance of structures. And there's some useful examples here around roads, railways, bridges, systems, which might mean drainage networks, for example, and processes in one of the engineering areas listed in the Act. The third criteria is that the service must be an engineering related design, construction, production, operation or maintenance activity, and it defines here a design as being an iterative process informed by the application of engineering principles and data. Construction and production are the respective processes of directing the construction of a structure, and operation and maintenance is defined as performing and checking significant changes relating to servicing, repairing or replacing devices, equipment, machinery, and, for our purposes, infrastructure. The fourth criteria is that the service is not provided just in accordance with the prescriptive standards, and we will provide some more information about a prescriptive standard shortly. But suffice to say, a service isn't a professional engineering service if it's provided only in accordance with a prescriptive standard. So of course, the opposite is true. A prescriptive standard is defined by the Act as a document that states procedures or criteria for carrying out a design or a construction or production activity, the application of which doesn't require advanced scientifically based calculations. And as I said, there are a separate document providing information about what is or isn't a prescriptive standard released by Consumer Affairs Victoria and amongst the consultation documents that are available from engage.vic.gov.au. Now, we talked about 5 areas of engineering that are to be regulated in the first instance under this Act. They are civil, which is obviously important for our purposes, structural, mechanical, electrical, and fire safety. The scheme has been designed to be extended over time to incorporate other areas of engineering, for example, disciplines such as chemical, automotive, or aeronautical engineering. And the consultation materials provide information about each of those disciplines. I won't go through them all, but we've singled out the civil engineering discipline as being most relevant to most of our members. Civil engineering is defined as engineering that involves the research, design, construction and maintenance of the physical and natural built environment, covering structures made of steel, concrete or timber, for example, roads, railways, bridges, airports, pipelines, dams, canals, harbours, dockyards, towers and buildings. It's also concerned with analysis of the likely behaviour of soil and rock, concerned with environmental impacts such as transport impacts, urban development and municipal services, resource protection of building and construction of other infrastructure and service industries, and the collection of sewage and industrial waste. So some pretty broad guidelines there on what civil engineering is taken to be, and flowing from that, of course, is the fact that anyone who's working in those areas as a civil engineer or undertaking civil engineering work needs to be regulated. There's a little more interesting information about civil engineering here, and that is to say that several different sub-disciplines of civil engineering have been identified. They are structural, environmental, geotechnical, traffic, transportation, road and rail engineering, and coastal engineering, hydraulic and hydrology engineering. And so engineers working in any of these sub-disciplines must be registered, but in the area of civil engineering, so the category of civil engineering, it's unlikely, as far as we can see, that there will be subcategories introduced for these 6 or 8 sub-disciplines, as they're called. So people working in these spaces will need to be registered in the civil category. Now, we talked a moment ago about the 2 broad exemptions, and it's time to have a look at each of those because they have some significant implications for who within an organisation needs to be registered and perhaps who doesn't. We'll look at both of them, the direct supervision exemption and the prescriptive standard exemption. The first one is the direct supervision exemption, and it's defined in the Act to mean the action of a supervising registered practicing professional engineer, being the supervising registered engineer, directing another person, an unregistered person, in the carrying out of professional engineering services, and also overseeing and evaluating the work that they do. So again, there's a little more information provided by the consultation materials. It identifies 6 elements that must be met to satisfy the direct supervision exemption of the Act. And it goes on to say that the supervising registered engineer must provide direct supervision, have sufficient knowledge of the area in which they are supervising activity. They must direct the unregistered person, they must oversee the unregistered person, they must evaluate the work of the unregistered person, and most importantly perhaps, they must take full responsibility for the service undertaken by the unregistered person. And again, there's a little more meat on the bones provided for each of these 6 elements. The first is that the supervision is direct, so it can't be through a third person. It must be via direct contact with the unregistered person. It need not be in person, but it may be through written correspondence, letters, drawings or emails, for example, by telephone or via voice or video chat. For supervision occurring between a supervising registered engineer and an unregistered person in a separate location, it may be carried out under specific instructions which may include direction on what to observe, check, confirm, test, record and report back on. So pretty comprehensive requirements there for the supervision of unregistered people in a remote workplace. When engineering decisions are required, contact must first be made with the supervising registered engineer by the unregistered person so that they make the engineering decisions and provide any further instructions or directions to the unregistered person. So some explanation there around the meaning of direct in terms of direct supervision. Some further distinctions here around the responsibility of the supervising engineer to be competent and to have sufficient knowledge in the area that the service is being performed. They will need to have that competence in the professional engineering service and of course the discipline in which that service is being undertaken and in which they are registered. So the civil engineering discipline, for example. The level of competency and knowledge required of a supervising registered engineer will depend on the nature of the service being provided and the circumstances of each situation. But the important thing to note there is it's a decision that has to be made by the supervising registered engineer. They should only supervise a service that they are competent to perform by virtue of their training and experience, and that is in the area of engineering for which they are registered. They should also ensure that they adequately understand the service being provided before accepting responsibility for the performance of that service. And we'll talk a little more about responsibility in a moment. They must direct the unregistered person. So in other words, they should not merely observe the carrying out of service, but they must be in control of the carrying out of that service in the sense that they are directing the unregistered person and reviewing their work. So that, again, some specific requirements around what directing actually means. They must oversee the work of the unregistered person. They must have sufficient control over the outputs of the service to ensure it's being carried out to the standard expected of a registered professional engineer. They must be involved at all stages of the carrying out of the service by the unregistered person. Simply providing an end of project or service approval or review, a check, a sign-off, a certification is not enough. They must be actively involved at all stages of the service provision. And again, the level of direct supervision required is a matter for their professional judgment, which is going to vary, perhaps depending on the complexity or risk of the service being undertaken. But as we've mentioned, it's worth remembering that the supervising registered engineer is the one who takes responsibility for the service. They must also review and evaluate the carrying out of the service by the unregistered person. They must be satisfied at all times that the unregistered person is exercising adequate knowledge, skill, judgment, and care, and that the service they're carrying out is to the standard required of a registered engineer, and it's undertaken in a professional and competent way. This obviously requires the supervising engineer to be satisfied about the information the unregistered person has gathered and any calculations or judgments they have made to apply principles. And finally, we've touched on this a couple of times already, but the registered supervising engineer must take full responsibility for the service. That means that if a complaint is made about the standard of service, the supervising registered engineer must accept that the complaint will attach to them as the person who provided the supervision, and that they may be the subject of investigation and potentially any disciplinary action. So none of that obviously should be taken lightly, and questions need to be asked about, first of all, who finds himself in a supervisory role, who's likely to find themselves in a supervisory role, both now and potentially in the future, and are they conscious of the responsibility that they take as a supervisor of unregistered people, and are they able to do that with full knowledge and care and competence in all of the work that's going to be undertaken by the unregistered person. It's worth just having a look at the obligations that are imposed on each party, either side of that supervision line. In the first instance, there's obligations attaching to the registered engineer that they must take full responsibility for the professional engineering service being performed by an unregistered person. We've just spoken about that. They must keep records, and they must be careful not to take on responsibility for more unregistered people than they can reasonably supervise at one time. And of course, that's a matter for some professional judgment. As far as the unregistered person is concerned, they can't act independently or take responsibility for professional engineering services without consulting their supervising registered engineer. They must ensure there's appropriate direct supervision for each service they provide, and they too must keep records of presumably what was done and who their supervisor might have been at the time. So there's a lot to consider there. The second exemption is that of a prescriptive standard, the prescriptive standard exemption. And again, there's information provided in the consultation materials that helps define what a prescriptive standard actually is. It essentially means a document that states procedures or criteria for carrying out a routine design, construction, or production activity, the application of which does not require advanced scientific calculations. And again, there's information provided by the consultation materials. For a standard to be a prescriptive standard, it must meet 4 criteria. It must be a document, it must state procedures or criteria for carrying out the design or the construction or production activity. It must require no engineering judgment to apply the stated procedures or criteria, and it must not require any advanced scientifically based calculations. So looking at each of those 4 in a little more detail, the standard, first of all, must be in the form of a document. It must physically record in some way the procedures or criteria for the activity it covers. Verbal instructions and procedures or criteria carried out from memory without being documented cannot be a prescriptive standard. It may be physical or electronic, which is useful. It may meet the definition of a prescriptive standard irrespective of whether it's published by a body such as Standards Australia or is produced and endorsed by a registered professional engineer. However, many Australian standards may not meet the definition of a prescriptive standard as they require engineering judgment to be exercised and/or advanced scientifically based calculations. So that's the first criteria. Second criteria is the document must state procedures or criteria for carrying out the activity to which it relates. Procedures are defined as the way the activity is to be done. Criteria are defined as the principles and standards the activity must comply with and with which it will be assessed. If a document doesn't state one or more ways of performing or conducting an activity, or one or more principles or standards by which the activity will be assessed, it is not a prescriptive standard. A prescriptive standard requires that no engineering judgment is required. If the procedures or criteria require an engineering judgment, the document is not a prescriptive standard. So a prescriptive standard will usually apply to a repetitive engineering activity that is routine and has minimal risk or scope for misinterpretation. And finally, a prescriptive standard should provide a simple, well-described and comprehensive approach that clearly explains how to carry out an activity. It must not require advanced, scientifically based calculations or interpretations which require engineering judgment. If calculations in a standard can only be made by a person with the level of knowledge and experience of a registered practicing professional engineer, the standard is not a prescriptive standard. Now we're going to have a look briefly at the regulators, and there's an important reason for this. It's not necessarily to explain how the scheme is going to operate, it's more to explain some of the registration requirements. The key party is obviously Consumer Affairs Victoria, which has responsibility for administering the Act, and they will do that through the Business Licensing Authority, which is a division of Consumer Affairs Victoria. CAV will also monitor compliance with the Act. They'll investigate complaints and, if necessary, they'll prosecute offences under the Act. The Business Licensing Authority, as a division of Consumer Affairs, will receive and determine applications for registration and registration renewal, which will include an assessment of an applicant's fitness to practice, which will include probity checks, inclusive of criminal history checks and other matters relating to fitness to practice. They'll also approve and revoke assessment schemes, and as well as maintaining a register of professional engineers. Now, the reason for mentioning assessment schemes and assessment entities is because they are the ones that will assess an applicant's eligibility for registration. So whereas the BLA assesses fitness to practice, assessment entities will, in the first instance, assess eligibility for registration. Now, in Victoria, as far as we expect, there will be two assessment entities at least. One is very likely to be Engineers Australia, and a second is very likely to be Professionals Australia. There may be others, but they are certainly two that we expect to be announced over the coming months. These assessment entities will assess eligibility against 3 criteria: qualifications, experience, and continuing professional development. The qualification requirement, as best we understand at the moment, is a 4-year Bachelor of Engineering degree accredited by a signatory to the Washington Accord. The experience requirement is 5 years relevant engineering experience in the last 7 years, with 4 of those 5 years being postgraduate experience, and also demonstrated competency in 5 elements of the Australian Engineering Competency Standards. Those standards are available from the Engineers Australia website, amongst other places. And there is also a continuing professional development obligation that kicks in on registration renewal. So you don't have to have 150 hours of structured CPD in place at the time you register, but the meter starts running, if you like, from the date on which you become registered, and needs to be demonstrated when you apply for renewal in 3 years' time. And as you can see there, for full-time registered practicing engineers, there will be a requirement for 150 hours of structured CPD every 3 years. Now, we're not entirely sure what structured means. We have made a submission to Consumer Affairs already, recommending that some more clarity be provided around that word, so that everybody, including ourselves, knows what sort of CPD activity is eligible and meets that definition of structured. But you can see there the qualification, experience and CPD requirements for registration and registration renewal. Now, in terms of commencement, this news will be interesting, I think, to most people. The Act itself comes into operation on the 1st of July. Registrations will be available from that date, assuming we have at least one assessment entity in place before that time, and I'm sure that'll be the case. But it's worth noting that Consumer Affairs Victoria proposes to phase in the operation of the Act by engineering discipline, over a 3-year period. And they're doing this through regulations to the Act, and you can see an extract here. I've only taken one section out of the regulations. It's the key one from our point of view at the moment. There's plenty more, and I encourage you to download those draft regulations from the engage.vic.gov.au website and have a look at it for yourselves. But the way Consumer Affairs is proposing to phase in registration is to, first of all, exempt everybody from registration from the commencement date being the 1st of July 2021, and then to progressively remove that exemption under sub-regulation 1 that you can see on the screen there. The first exemption to be removed will be that applying to fire safety engineers, and that'll be removed on the 1st of December 2021, so about 5 months after the Act comes into effect. The exemption for structural and civil engineers will be removed on the 1st of October 2022, from electrical engineers in 2023, and for mechanical engineers from December 2023. So you can see there the civil engineers, which are most of our membership, don't need to be registered until the 1st of October 2022, which is about 2 years from now. But it's also worth remembering that registration will be available from the 1st of July next year, which is only about 9 months from now. And our message to all of our members is to, I guess, get organised early, register as soon as you can, and have everything you need, both personally and within your organisations, in place as soon as possible, and ideally by the 1st of July next year, but certainly as far in advance of October 2022 as you can do, because that really is a drop-dead date in terms of mandatory registration. And I think it's fair to say that anyone who doesn't have their registration in place by that date in 2022, but who finds himself providing a professional engineering service, will be in breach of the Professional Engineers Registration Act. Now, just to finish off, we've covered a lot of information. All of what we've covered has been taken from 6 of the 8 documents that Consumer Affairs Victoria has released for public consultation. There are 2 more that we haven't covered. One is a code of conduct, which very much governs how registered engineers are expected to behave professionally. It sets out 14 obligations for registered professional engineers. Certainly, I encourage you to have a look at that. There is also a cost recovery options paper, which is simply being used to inform a regulatory impact statement that will be released possibly before Christmas 2020, maybe early in 2021. That's certainly worth having a look at as well. It's worth noting, though, that state government policy is that is for full cost recovery of initiatives such as this. So I think it's fair to expect that the state will be looking to recover the costs associated with implementing this regulatory regime via registration fees. But if you have a contrary view to that, if you think that's unreasonable in any way, then I'd encourage you to have a look at that cost recovery options paper available from engage.vic.gov.au and make a submission, along with any feelings you might have either in support or opposition to any of the other documents that are available there, and to make that submission before the 7th of October 2020. Now, as we said at the outset, and as you might now agree, there are implications in all of this for individuals, obviously, as registration attaches to the individual, but also for organisations who employ engineers or who provide engineering services in one way or another through their staff. We see implications for staff roles and responsibilities, not just for engineering staff, including their managers, not just for, but also for outdoor staff, including their supervisors. And it's worth thinking through very carefully the responsibilities and the day-to-day duties of managers and supervisors. And it's critical to understand whether from time to time they are doing work that might fall under the definition of a professional engineering service, or in fact whether they're supervising people who are undertaking, unregistered people that is, who are undertaking what would be defined as a professional engineering service. If that's the case, then they are going to need to be registered themselves. The question that flows from that, obviously, is whether people in those roles can become registered, whether they have the appropriate qualification and experience requirements to become registered, or whether they might be able to become registered through an alternative pathway that are available, and information about that will be made available by the assessment entities once they're appointed. There's implications for employment agreements, position descriptions, remuneration, and potentially the reimbursement of compliance costs. And as we said earlier, there's potentially implications for smaller organisations around insourcing versus outsourcing their professional engineering services. So a lot to think about for organisations big and small, local government, state government, consultants and contractors. And it's worth pointing out that for many of our contractors, in fact many of our councils too, with yellow fleet and mechanical engineering obligations, perhaps in the maintenance of those fleets, it's worth asking whether any of the work that any of the staff do in a mechanical engineering sense might fall within the definition of a professional engineering service. It may mean they need to consider registration as well under this Act. So it's not just civil engineers that might be affected at a local government or a contractor level. That's all we have for now. I know I've said this before, but I am going to say it again. All of the material we've taken for this presentation has come from consultation documents that have been made available by Consumer Affairs Victoria. They're available from the website you see on your screen, engage.vic.gov.au/engineers-registration. Submissions against any of those documents, either in support or opposition, are required by the 7th of October 2020. So I encourage you all, at the very least, to download those documents and consider your own circumstances and consider the roles and responsibilities of your team members in the context of those guidelines that have been provided around direct supervision and professional engineering service in particular. Make a submission if you want to, but at the very least, we'd encourage everybody to start having these conversations within their organisations, involve your director, involve your CEO if you have to, involve your HR manager if you can. These conversations need to be had. Infrastructure development and delivery is probably one of the biggest risk areas for any organisation, certainly for local government. And it's important, in fact, it's critical that organisations aren't exposing themselves to risk, but most importantly, that individuals aren't exposed to risk either knowingly or unknowingly by their organisation. So these are really important conversations to start having. I know that some councils have begun having them, but if yours hasn't, I'd make sure that you begin to have those conversations very, very soon. If you have any questions, please direct them to vic@ipweae.org/vic@ipweae. I'll say that again, vic@ipweae.org. They will come to me one way or another, and we'll respond either directly if it's a straightforward question, or if it has application for the wider membership, we'll perhaps respond through our newsletter. Thank you very much for listening. I hope it was informative, and we will probably have another update towards Christmas if the regulatory impact statement has been released. So I look forward to speaking to you all then. Take care.